Welcome, I'm Pam Flores. I'm so happy to be here with you. I hope this presentation is informative and that you will learn things that you can put in place to protect your family. And at the end, you'll get two gifts from me. We have a lot of ground to cover today, so let's get started. So, as I mentioned, I'm Pam Flores, and I've practiced law for over 20 years now. For most of my career, I was a litigation attorney who represented individuals and companies in contract and business disputes. When clients came to me, they already had an issue that they needed assistance with. A couple years ago, I decided I wanted to get back to the reason I went to law school in the first place. That was to help people. I transitioned my practice to only estate planning as I really enjoyed helping people make sure their family was protected should anything happen to them. What happens most of the time is that planning for the future is something most people know they should do, but they procrastinate, then eventually it becomes too late. I've made it my mission to help other families avoid the terrible consequence that can occur if the right planning isn't in place by supporting them to get plans in place right now before it's too late. On a personal note, I also do estate planning because it's important to me that my family knows I care about them and want them to be cared for when something happens. My why is my husband and my three furry kids. Should anything happen to me, I want it to be as easy as possible for my husband by staying out of court. And if anything should happen to the both of us, our pets will be taken care of through a pet trust that we set up for them. I mentioned my why on the previous slide. I have a question for you. Why did you come today? You probably may have asked yourself, what is estate planning exactly? I hate the term because it's too legalese. So here's my description. It's a proactive plan you make about what happens to you if you become incapacitated, and what happens to your loved ones and your assets when you die. It's legally enforceable, and it allows you to state your wishes and have them honored. It's best to think of it as a plan for life, not death, because once you've made these choices and made them legally enforceable, you can enjoy your life more fully and with less stress, knowing that you have done all you can for the people you leave behind. Did you come for the peace of mind knowing what would happen to your assets at your death? Did any of you come to find out how to make sure your family doesn't pay estate taxes unnecessarily? Or maybe you came to make sure you'd be taken care of in the best way possible, and the best decisions would be made for you if you became incapacitated. Here's the thing, estate planning is something you do for your loved ones. It's for you, yes, but it's for them more, because someone will have to make sure your stuff is handled after you die. By making those decisions and plans now, you are relieving a huge burden for them, and you're saving them a potentially expensive, lengthy mess to deal with. So, estate planning is a roadmap for your family once you're gone, your comfort if you become incapacitated, and for what happens to your business if you own one. And by doing it now while you can, you'll have total assurance that everything will be handled smoothly when you're gone. But most people don't have a plan. Type in the chat box and answer this. Do you have a plan? A common thing I hear from people is that they don't have enough money to justify an estate plan. Estate planning isn't about how much you have, it's about making sure what you do have goes to the people you want in the way you want it to, when you want them to have it. People also assume that since everything goes to their spouse, that they don't need a plan. Without a plan, even your spouse will have to go to court to be able to make decisions for you if you become incapacitated. Also, if something happens to the both of you, what happens then? Yes, estate planning is an investment. However, when you compare what it will cost you now versus what it will cost your family to go to court to deal with all of it, it will cost way more than anything you would pay now. With no plan, it involves going to court. First, all your accounts are frozen. Somebody pays your funeral expenses, someone pays your mortgage if you have one. Otherwise, your house will be lost to foreclosure. And that's usually the biggest asset for people. I've seen this happen. A daughter could not afford to pay her mortgage and her dad's after he died. So his house was foreclosed. That was his only asset, and it had a bunch of equity that would have gone to her and not the bank. I doubt this is what her dad would have wanted. There are many steps throughout the probate process with delays built in along the way, and the fees are speculative. The average for Wisconsin residents is 5% of your total assets. So for every 500,000 that goes through probate, your family will pay up to $25,000 in court costs, attorney fees, and other expenses. It also routinely takes about 12 to 18 months for a probate case from start to finish. If you have kids, a judge who is a complete stranger to you and them will decide who raises them without your input. And speaking of kids, they get whatever is left after all the creditors are paid off at age 18 outright with no strings attached. Incapacity is also dealt with in a probate court. So someone will have to file a case to be able to manage your money if you're too sick or injured to be able to do it yourself, and to make medical healthcare decisions if you can't communicate. That person will have to qualify to post a bond and make premium payments. Finally, many assets get missed because we don't share our financial circumstances with others. Does someone besides your spouse or partner know where you do your banking? Who holds your insurance policies? What brokerage firms do you use? Would they know how to find account numbers? So let's review the state's estate plan for you. If you have no estate plan and you become incapacitated or die, the state has an estate plan for you, and it's called going to court, so a judge can appoint someone to make decisions for you or to give your family access to your assets or direct where your assets should go. This court process is called guardianship or conservatorship if you are incapacitated, or probate if you've died. The court decides where your money goes, and it may not be to who you would choose or in the amounts you would choose. Court is costly. There are attorney's fees and executor fees, appraiser fees, court filing fees, bond premiums, and creditor claims. Probate today takes a minimum of 6 to 18 months in Wisconsin, and it could be longer. And during this time, your loved ones may not have access to your assets. Who would you rather have your assets available to them immediately, your creditors or your children? Most people do not share information as to the location of their assets. After all, that can be extremely private information. But when assets are missed after someone dies, that money goes to the government, to a department that holds unclaimed assets. So asset loss is a real problem. Wills also go through probate too. So the process is essentially the same, but you get more control over who gets your stuff and who raises your kids. Some of you may already have seen an attorney about a will. That is usually a one-time transaction, and then you stuff the paperwork in a drawer and never look at it again. Are you confident that the documents stuffed in your drawer will work when you need them to? What some people are unaware of is that the court process is also totally public, meaning anyone can go down to the courthouse and pull your court records to see what you own and who is getting it. This is the will of Jackie Onassis. Would you like to see the will of John Lennon, JFK Jr.? How about Jerry Garcia? You could, because they all went through the court process. My point here is that a will is public and it doesn't avoid probate. When a will enters probate, it puts all of the creditors out there on notice that your loved ones will be receiving money. The only plan that is private, avoids probate, ensures your children receive your assets when you want and how you want, and can save you substantial estate taxes, is with the properly funded trust, but we'll talk more about that later. For now, if you want to make sure your family stays out of court, make a note that the only way to do that is through a trust. Finally, without a plan or with a will, your children would be entitled to all of your assets outright without any restriction at 18. My friend's husband received about $50,000 when he was 18 and another $150,000 when he was 21. As a result, he didn't graduate from college until he was over 30 and never really learned to support himself financially. If you have minor children at home and you want to make sure that they do not receive what you're leaving behind at the age of 18, make a note that you need to make sure your kids don't inherit money at age 18. And one last piece, you may want to ensure that your kids receive their inheritance from you, protected from lawsuits against them, future creditors, or even a future divorce. For example, a relative of mine got married and then her dad died. He left her a small inheritance of $50,000. Because it came to her outright, and she didn't know how to keep it in a separate account, as most people don't, when she got divorced, her husband got half of its value. If her dad had left the money in a protected trust, she could have used it to invest in her business or real estate and kept all of it when she got divorced. Having assets your children will inherit in a protected trust will ensure your children's inheritance is protected from lawsuits, creditors, or a future divorce, no matter how old they are. Before we move on from talking about your kids, if you do have minor kids at home, I want to tell you two quick stories that could illustrate where your kids are at risk, even if you already named guardians in a will. If you have not named guardians at all, as 69% of parents haven't, and something happens to you, the choice about who raises your kids will be left to a judge to decide. Several years ago, the Barber family, 2 parents and 3 sons, went on vacation in Arizona. They were from California. While there, they were in a car accident and both parents died. The boys lived, and when the authorities finally found a family member to pick them up, they found one of the sisters of the mom. And that sister decided that she could get custody of the kids and their money, and prevented them from seeing any other family members. After more than $100,000 of court costs later, and nearly a year of litigation and a huge family fight, a judge decided that a different sister should raise the boys. A judge then appointed a financial conservator over the boy's inheritance. This person was able to charge to the tune of $100 an hour, and the boys will receive whatever is left at the age of 18. Even if you have a will naming guardians, your kids could be at risk. My colleague realized this when she was out to dinner with her husband, and her baby daughter was home with their 16-year-old babysitter. She realized that she had named guardians, but they all lived across the country, and no one would be able to find her will anyway. At that point, she realized that the authorities would have no choice but to take her daughter out of her home and into the care of strangers until they could find her will, locate her named guardians, and they could make their way across the country. Because this was not acceptable to her, she created something called a Kids Protection Plan that ensures no kids are at risk ever from that happening by filling in the gaps left by a will-only plan. Now, we've talked a bit about what would happen to your kids if you have minor children, and to your financial assets if you become incapacitated during your lifetime or when you die. But what about what happens to you if you become incapacitated? This is Terry Chavo. Terry did not leave any advance directives to indicate what medical care she would have wanted. Her husband said that she would not have wanted to be kept alive if she was in a persistent vegetative state. However, Terry's parents sued to keep Terry on life support. A court battle ensued that took years to make its way through the court system, all battling over who had authority to make the decisions for Terry, pitting family against family. These terrible events could have been avoided if Terry had properly executed a simple document. Now, many of you may have executed such a document, but I can guarantee that for many of you, it's out of date and won't work when you need it. And it's unlikely to be comprehensive enough, providing detailed guidance on how you want to be cared for in the event you become incapacitated. If you decide that you need a plan, or you need to update your old one to make sure it's still valid, you can choose to do it yourself on LegalZoom or work with an attorney. Here's the difference between the normal way attorneys work and the DIY method, and what I do for my clients. Most attorneys only do a few things, meaning that they fail to plan for all scenarios. That leaves you open to the strong possibility that your plan won't work when you need it to, and that you paid them money for some pieces of paper. I, on the other hand, make sure your plan works when you need it to. The table on the right shows what needs to be done so that you have a plan that works. Many people think they can avoid all of this by either owning property jointly, designating a beneficiary for their assets, or signing a will. Joint ownership has many problems. If you remember when you were in escrow on your home, you probably remember that the escrow agent asked you how you wanted to take title to your home. If you're single, you said just in your own name. If you were married, you probably said joint tenants. If you said to take property as joint tenants, you have the benefit of avoiding probate upon the death of the first of you to die. But the downside is that you can't ensure that the surviving joint tenant won't give all the property away to a future spouse or lose all of the assets to creditors. And you lose the benefit of erasing all of the built-in gain on the property upon death. If you took title as community property, as most of us do in the state of Wisconsin, you get to erase all the built-in capital gain when one of the joint tenant dies, and half of the property would be subject to probate. Designing a beneficiary is an option where assets permit, but many assets don't permit beneficiary designations. And where you designate a beneficiary, the beneficiary has unlimited control over the assets. Worst of all, naming a minor as a beneficiary just ensures that your insurance or retirement account will end up in court if you die before your kids are 18. Now, there's a way to avoid this, and it's called a revocable living trust. It offers a lot of flexibility and avoids probate, saving time and money for you and your loved ones. Assets go to kids at the ages you want or can be fully protected from taxes, creditors, former spouses, or personal injury lawsuits. It's not hard to set up, but it does require some paperwork and a little work on your part. The best part is that it includes your incapacity. And the way I do it ensures that no accounts get missed and go to the government, but are available to your loved ones immediately. That also ensures your funeral expenses and mortgage will be paid by you, not by your family having to come out of their own pocket. When you create a trust, you get to choose how to distribute assets to your heirs. They don't just receive assets at 18, but instead according to a schedule you determine. Most trusts distribute assets to their beneficiaries at ages or stages. For example, 1/3 at 25, 1/2 at 30, and the remaining balance at 35, or 1/2 upon graduation from college, and the balance upon graduation from graduate school. This is an acceptable way to plan, but there's an even better way. How many of you would like to own assets that can never be touched by creditors, will never be subject to estate taxes, and can never be taken away in the event of a divorce? Yes, of course, we'd all like that. Now, what if I said that I could give you all of this, but you couldn't control those assets? You'd be a little less interested. Well, in my living trusts, you can give your children assets that can never be touched by creditors, will never be subject to estate tax, and can never be taken away in the event of a divorce, and you can give them complete control. These are techniques that only the most knowledgeable estate planning attorneys are taking advantage of, and I know you want them included in your plan. This won't apply to many of you, but just in case any of you do have assets in excess of $11.7 million or are expecting an inheritance that could put you in that category, you need to know that your family could lose nearly half of all your assets in excess of that, even if you receive it by inheritance. I won't spend a lot of time on that now, but it's important because the current administration is proposing to bring that figure down to 3.5 million per person, and as your assets grow into the future, that figure may have more of a significance to you. So we know what doesn't work: doing nothing, having a will only, or even getting an estate plan created by a lawyer who just focuses on documents, doesn't ensure the protection of your kids or assets, doesn't ensure that your assets are owned in the right way, doesn't keep your assets out of court or out of the Department of Unclaimed Property, and very likely could leave your family unnecessarily at risk of a big mess in the event of your incapacity or when you die. But here's the thing, what you need is different than what another family needs because your family dynamics are unique to you. Your assets are unique to you. And the law, as it applies to your family dynamics and your assets, are specific to your circumstances. I found from my own experience after working with many clients that the most important things you leave behind are not financial. They're your stories, your humanity, the proof that you were alive once and that you touched other people's lives, your legacy. That picture is of my mother. She lived until age 47 before she passed away from cancer. I was young as well and could not imagine her not being here. Before she passed, I wished I had recorded her telling me some of her life stories. That would have been really special. Just to see her talking, hearing her voice would have been priceless. So, one of the things that I do when I work with clients is a legacy interview. We sit down and chat for an hour about your childhood, your family, funny memories, whatever you want. If you have small kids, you talk about your wishes for them, as well as instructions to the people you've chosen as their guardians about how you want them raised. The interview is on video, so your loved ones will be able to see and hear you for the rest of their lives. It's a special experience, and my clients love it. If anything I've said today has you thinking, would my assets end up in the government's unclaimed property? Or what would my family have to go through to take care of my affairs? I want to give you those answers in a family wealth planning session. There, you'll tell me about your family dynamics, and I'll tell you about the law, so you'll know exactly what would happen to the people you love. You'll tell me what about that works for you and what doesn't. Then together, we'll choose a plan that's best for you from a cost perspective. Normally, that session is $750 because I set aside up to 2 hours and it's a working meeting. But because you're here and took the time to become educated about the probate system, and if you do some homework ahead of time to gather all of your asset information, which is critically important whether you work with me or not, so your money doesn't end up lost, I'll give you that session at no charge. You can schedule your family wealth planning session with me today using the button below. You can also reach out to me directly via email or through my website, www.floreslegalgroup.com. So I've already mentioned I want to give you the planning session for free, but I want to one up that right now. The number one reason people fail to plan is procrastination. I'm going to give you a $250 incentive to not procrastinate any longer because I know it's something you want to do for your family anyway. You know how I know? Because you took the time to be here and to learn. So I've created a golden ticket that represents this offer of $1,000 worth of legal services for free. All you need to do is claim it. You can either click the button below or contact me directly to schedule. You'll also get a link in your email after this webinar is over. You can schedule through that. If you have any questions about whether planning is important for you to do right now, or whether you can do legal planning on your own, I'm here to answer those questions. Go ahead and type them in the chat box. If you decide to wait and do it later, that's fine, but do it before the ticket expires 1 week from now. Again, my job is to incentivize you to stop putting it off and to help make it as easy as possible. So, to summarize, your next steps are to claim your golden ticket today to get $1,000 worth of free legal services. You can contact me directly, or you can schedule a free 15-minute consult call with me on my website. Thank you so much for being here, and I look forward to meeting you and to supporting you to make informed, empowered choices for you and your loved ones. Bye for now.